welcome to today's webinar by 10 the Education Network. For technical assistance, please phone 03 8601 7709. This webinar is live and interactive. You're encouraged to post questions to the presenter by using the Q&A button. Your questions will be answered by the presenter at the conclusion of the session. I'll now hand you over to our speaker, Kimberly, to begin.
Hello, everyone. Thank you so much for taking the time out of what I'm sure are busy days to join me to discuss what I consider to be a very interesting topic. And that topic is, to the bitter end, what amounts to the ending of a de facto relationship. I was really passionate about this topic and it came about from one of the cases that I will be speaking about today. And what it highlighted to me, which I wasn't previously aware of, was the differences that apply in legislation across Australia in terms of the rights that former de factos have after the death of a former de facto. And it has led to discussions with the Department of Justice in relation to legislative reform here in Tasmania, which is where I practice, and looking at legislation in other jurisdictions and being envious, I suppose, of that legislation and the rights and protections that it does provide to people who have ceased to be in a de facto relationship, or where a court determines that they had ceased to be in a de facto relationship prior to the death of one of those parties. And then that changes the rights that that party may have in terms of making family provision claims, rights under intestacy, rights to commence or to continue family law proceedings. So that is what we're going to be focusing on today. The key things that we're going to focus on are the relevant tests for determining whether or not a de facto relationship exists, the relevant tests for determining whether a de facto relationship has ended, and how the ending of de facto relationships impacts wills, rights and roles under discretionary trusts, enduring appointments, binding death benefit nominations, life insurance nominations, intestacy, superannuation death benefits, family provision claims, and family law proceedings. Now, I'll wrap up by looking at some really interesting cases. I might not get to all of the cases, but they are explained in detail in the paper. I think the reason why there are so many cases and there are so many things that I want to talk about is every time I pick up this paper, or every time I read a new case, I want to include it in the paper because I just find it to be incredibly interesting. As an area of law and something that really does affect every element of an estate planning and an estate administration practice, constantly or very regularly leading into estate litigation. I always like to start any presentation with some statistics, and what is really clear is that the number of de facto relationships across Australia are increasing and the number of marriages are decreasing. So it's said that 1 in 7 Australians are now in a de facto relationship, and that people in de facto relationships are more likely to separate than married couples. Just setting the scene in terms of the importance of the change in society and the change in expectations. And in lots of instances, when we look at legislation around Australia, where legislation just has not kept up with those changes to relationships. In terms of determining whether or not a de facto relationship exists, it is not the focus of this presentation, although it is still very relevant. And so I did just want to spend a little bit of time on it. There are whole papers and extensive materials on determining whether a de facto relationship exists. A lot of the cases that I will talk about today, some of them do look into the question of whether a de facto relationship existed. But for the purpose of this presentation, we really are focused on whether or not that de facto relationship had come to an end. And in almost all of the cases which I talk about, they sort of pass over the question, or it wasn't challenged as to whether or not the parties were in a de facto relationship. It was whether or not the circumstances of those cases proved that that de facto relationship had come to an end. Estate law differs greatly from jurisdiction to jurisdiction. And although the term spouse may be simple to understand, or de facto may be a commonly used term, in a legal sense, it is not as simple. Different legislation applies in every Australian jurisdiction to de facto relationships, and not just different legislation, different terms apply. There are so many different terms that apply, and I've listed a few of those on the current slide. In Tasmania, we use the term significant relationship. New South Wales, de facto relationship. Victoria, domestic partnership. Queensland, de facto partner. South Australia, domestic partnership, and the list goes on. Now, it's not just states and territories that use different terminology and different tests. It's also under superannuation legislation. We use the word spouse, and that includes a person who, although not legally married to a person, lives with the person on a genuine domestic basis in a relationship as a couple. We then have the Commonwealth legislation under the Family Law Act, which refers to de facto relationship. Now, for ease of reference throughout the balance of this presentation, unless specifically referring to a relevant jurisdiction, I will use the term de facto relationship and de facto partner when referring to the legislation as it applies across each of those jurisdictions. Determining whether or not a de facto relationship exists, to determine that there is a standard test, I suppose, that does apply. Some jurisdictions have different factors that they take into account, but whether or not a de facto relationship exists is determined on whether or not certain circumstances apply in a particular case. I've listed those again on the slide: the duration of the relationship, the nature and extent of a common residence, whether a sexual relationship exists. Interestingly, that doesn't apply in South Australia. The degree of financial dependence or interdependence, and any arrangements for financial support between the parties. Ownership, use and acquisition of property, mutual commitment to a shared life, the care and support of children, the performance of household duties. Again, interestingly, though, that factor is not relevant in Western Australia or in Victoria, and the reputation and public aspect of their relationship. Now, what's important when we look at these is that we will see these appearing again and again and again in superannuation cases in determining whether or not a de facto relationship has come to an end. So each of these key factors, what's really clear is that not all of them have to be present, but the court will consider each of those factors when determining when a de facto relationship in fact existed. Now, again, stepping straight into the depths of legislation here, in addition to those factors, when we're talking about intestacy in the relevant jurisdictions of Australia, there are additional requirements for the purposes of intestacy. So some states and territories require that parties must be living together. So we've got the ACT and Victorian requirements there, the Queensland requirements, the Western Australian requirements, South Australia and New South Wales and Tasmania. So most of them going between 2 to 3 years of those parties living together on a continuous basis or having a child together. One of the things that you may ask yourself is how are all of these factors relevant? Well, we don't live in a society anymore where a client may just have assets in one jurisdiction. And what's relevant in a deceased estate matter is that you might have different laws applying to an estate plan that's just been created in one jurisdiction. And therefore you should be aware of the legislation and the different changes that apply in other jurisdictions when you're providing advice to your client in your jurisdiction to determine whether or not it's necessary in order to get advice from another practitioner in another state or territory as to whether or not the outcome in their jurisdiction is going to be different. Now, that's very relevant when we get to the concept of family provision applications and whether or not a person is eligible in a relevant jurisdiction versus another jurisdiction. When we look at the superannuation legislation, what is really important to note under the superannuation legislation and throughout the paper, I do talk about a number of cases where it becomes very clear that AFCA's approach and the superannuation legislation is that there is no time requirement. So there's no 2-year requirement that a relationship must exist in order for the parties to be entitled to superannuation. Obviously, whether or not the person has died intestate, and therefore the intestacy rules apply. If the intestacy rules apply because that person died intestate, in those circumstances, that person, regardless of that 2-year requirement that applies on intestacy, would be eligible or may be eligible to apply for superannuation through the trustee. And as AFCA has provided in terms of decisions that they've made in recent times, it's very clear that it can be a short period or a longer period of time in order to satisfy the requirements under the superannuation legislation. Again, what we're seeing is those factors that I just went through in determining the duration of the relationship, the nature and extent of a common residence, and each of those things, sort of each of the matters that I've already covered. Now, what's important in this context is whenever you're dealing with a matter where there is a forma de facto, where you're trying to determine what their rights are under the legislation, you must place them into boxes. You must place them into, well, what are their rights under intestacy? Okay, if they died with a will, what are their rights in your jurisdiction in relation to making a family provision application? What are their rights in relation to superannuation? What are their rights under the Family Law Act? And is there any other option in terms of preserving or enforcing what they view as their rights or entitlements to that deceased person's estate or other assets like life insurance or superannuation? A concept that I want to just briefly touch on before we move on to the core of this presentation is the concept of registering a de facto relationship. So in all states and territories other than Western Australia and the Northern Territory, it is possible to formally register a de facto relationship. Again, in each state and territory, as I've listed here on the slide, they all call different things, and there are different pieces of legislation which all differ that provide how you can register a de facto relationship. Now, why would you register a de facto relationship? It's relevant in the sense that it may make it simpler for the parties to prove that they are in a relationship for the purposes of tax, superannuation, Centrelink, and other government payments. If a relationship is registered, the parties will not have to provide other proof that the relationship existed for any of these purposes. Importantly, a relationship that is registered in one state may or may not be recognised in another jurisdiction. Now, that depends on the mutual recognition provisions that exist under each of those pieces of legislation that I've listed here. We then move on to determining whether a de facto relationship has in fact ended. So unlike determining whether a de facto relationship exists, there is no legislative test or factors that are in legislation to determine whether or not a de facto relationship has ended. Now, we do have High Court authority and we have lots of different authorities that we've seen be applied. So this is case law that just keeps appearing because of the high number of de facto relationships that we have here in Australia. So very clearly in the High Court case of Fairbairn and Radecki, the High Court stated that in determining whether a de facto relationship continued to exist meant considering whether the necessary and desirable adjustments were being made by the couple to allow for the continuing of their shared life, explaining that if one party fundamentally acts contrary to the interests of the other in relation to the property of the couple, it may be possible to conclude that the mutual commitment to a shared life has ceased. Now, the following factors were listed by the High Court as relevant to the commitment of a shared life together. And again, you can see those factors, which we just went through, appearing once again. Reputation and public aspects of the relationship, sexual relationships. So each of those factors, again, once again appearing. Some interesting excerpts that I've taken from a number of cases which are really relevant or I found interesting and helpful in the context of determining when a de facto relationship has ended was the following statement from Fairbairn and Radecki, which is a de facto relationship may continue even though the parties physically reside at different locations and despite one of those parties suffering from severe illness. In Hibberson and George, it's a New South Wales Court of Appeal case, they said where one party determines not to live together with the other, and in that sense that keeps them apart, the relationship ceases, even though it merely be to enable the other party to decide whether or not it should continue. Now, in Brownell and Robertson, which was a Tasmanian Supreme Court case, what was the interesting excerpt from that case is a de facto relationship will depend for its existence on the mutual consent of both parties to be in that relationship. When consent is withdrawn by one party, the necessary element of mutuality is destroyed, and hence the relationship no longer exists. It is not the fact of separation per se, which is important. It is whether that separation manifests an intention on the part of one party to end the relationship, thereby withdrawing the necessary consent required for the existence of that relationship. Again, there are some more interesting statements. I'm not going to read those out, but I do encourage you to look at each of these cases, which I talk about in the paper in detail, in order to determine, what is it that different courts are going to look at when determining whether or not a de facto relationship has in fact ended. Are there circumstances of desertion? Are there circumstances of unilateral relocation of children? Are there circumstances of refusal to cohabitate or the refusal to communicate other than in writing? Now, again, each of these factors, interestingly, we will see come up in the cases that we will talk about today. Once we determine whether or not a de facto relationship has in fact ended, or if there is a determination that a de facto relationship has ended, when you receive instructions from a client that they say, I was in a de facto relationship, that de facto relationship has now ended, what I want to now go through is to focus on the different consequences that that ending of that relationship may have. So first of all, we start with wills and the ending of an unregistered de facto relationship, which you'll see I contrast with the ending of a registered de facto relationship. So in relation to the ending of an unregistered de facto relationship on wills, it's important to note that in all jurisdictions other than in Queensland, it will not necessarily have an impact on that person's will. So unless there is something provided in the will that says it's subject to me remaining in a relationship with that person, if a will provides for a de facto partner and that de facto relationship in fact ends, there is nothing in the legislation other than in Queensland which says that it revokes that provision made for that person under the terms of that will. Interestingly, Section 15B of the Queensland Succession Act has the same effect of divorce on the ending of a de facto relationship, and that being that the impact of the ending of a de facto relationship under Section 15B says that it will revoke the provision made for that person under the will. So it'll revoke any gift left to that person, the appointment of that person as an executor, and any grant made or power of appointment exercised under that will. Now, certain exceptions apply, but for those practitioners in Queensland, or for those of you who practice in other jurisdictions but have a client who have assets in Queensland, it's really important to consider whether or not the ending of a de facto relationship would in fact have impacted that. Now, one of the cases that I find really interesting is the case of the estate of HRA deceased, which is a Queensland Supreme Court case, and that is discussed in detail in the paper. But in that case, the relationship had broken down, and the fact that the de facto relationship had broken down meant that it was unnecessary for the court to consider whether or not an informal document or a document was an informal will document, in circumstances where they said, well, because we've determined that the de facto relationship has come to an end, it's not necessary for us to determine whether or not this document is an informal will document, on the basis that it would have been revoked under Section 15B regardless. The other case, which is interesting, but take it lightly because it is a Western Australian case of a single master, not a judge, and it's not binding on the Supreme Court of Western Australia nor courts in any other jurisdiction, is the case of Blythe and Wilkin. Now, interestingly, in that case, the will of the deceased provided the bulk of his estate to be gifted to my de facto wife, and then listed her name, Catherine Mary Murray. Now, the relationship ended and he died without updating his will. Now, the court, or the master in that circumstance, held that those words, my de facto wife, was a condition, and it was conditional upon her still being his de facto wife at the date that he died, and therefore to receive the entitlement under the will. I find this really interesting on the concept when I, consider a will my will, for example, where I say I gift this asset to my friend, whoever. Now, if we're no longer friends, does that mean that it was conditional? Now, my view is that if we're going to draft things on the basis that it is conditional upon a relationship existing, it should be expressed that it is in fact a condition that applies. The case of Kemp and Findlay is really interesting. It's a very recent case, and not overly relevant to what we're talking about here today, because it is a case of an informal will. But why I wanted to include it is because it really brings home the importance of a person who has ended a de facto relationship where they have gone through separation and finalisation of a family law property settlement in updating their will properly. Now, in this case, we had a situation where the person, so Andrew Findlay, who I understand is a well-known person, he died tragically in a boating accident in 2023, leaving behind 3 young children that he shared with his former de facto. Now, he and his former de facto had separated some years prior. They had entered into a financial property settlement in which she was paid $4.5 million, and she was also entitled to receive child support and different benefits. Now, after they separated, he updated in quotation marks his will. His previous will had gifted all of his assets to his former de facto and appointed her as executor. Now, he completed a new will online. He didn't print that will out. He didn't execute that will formally. He didn't have it signed in the presence of 2 witnesses. And he told everybody that he'd updated his will, and in those circumstances, the old will didn't apply. Now, the reason why I want to stress that it is so important that they update this is because in that case, the former de facto took the previous will and said that it was his will and therefore she was entitled to the entirety of the estate. Now, in that circumstance, they took the informal will, or that document that was found on his computer, and it was proved, in fact, to be his last will, and it therefore excluded any further provision for her. But what it stresses, and what I like about this case, is it really does stress what former de factos the steps that they may take to rely on a previous document, even where a property settlement has taken place. And unlike a divorce, where a divorce is final and there's been a property settlement, the finalisation of a property settlement in circumstances of the ending of a de facto relationship, again, are not going to affect a person's will unless there are conditions within that document. Now, moving on to the ending of a registered de facto relationship. So in Queensland, Tasmania, South Australia and the ACT, unless there is an express contrary intention in the will, the revocation or termination of a registered de facto relationship revokes certain aspects of that person's will. So in the same way that we might complete a will in contemplation of divorce or in contemplation of marriage, it is important that we do consider contemplation of registering a relationship or contemplation of revoking the registration of a relationship when we're giving estate planning advice. Moving on to trusts, roles, rights under discretionary trusts upon the ending of a de facto relationship. So it is vital where you're taking instructions from a client who has ceased to be in a de facto relationship, that we do review the deeds of any discretionary trusts in order to determine if it contains a definition of a de facto relationship. So what's important to remember is read the deed, read the deed, read the deed, in the context that the definition that might apply within the terms of a discretionary trust may in fact oust the otherwise applicable legislation in that jurisdiction. And so it is really important to consider whether or not a de facto remains a beneficiary of that discretionary trust, or whether the ending of that de facto relationship severed their rights and powers as a beneficiary. It may remove their rights and powers as a default or substitute controller. Now, I use the word controller to mean protector, appointer, nominator is one that I've seen recently, or principal, any of those terms where a person has a power of appointment to hire and fire the trustee, to veto decisions of the trustee, to take or provide consent to any action taken by the trustee. So really important to think about that, because if it is expressly provided for in the terms of the trustee, that a forma de facto is the person who takes on those roles, it will defer to them. Importantly, the ending of a de facto relationship will not remove a person's right where they are expressly named as a beneficiary, so not subject to the definition of a de facto by class, but where they're expressly named. It won't revoke unless otherwise provided the exercise of a relevant power of appointment or the appointment or default substitute appointment if they're expressly named within those documents. It also will not revoke or rescind those persons' accrued rights under the trust. For example, the right to unpaid present entitlements or to beneficiary loan accounts. Moving on to binding death benefit nominations and superannuation death benefits. So unless specifically provided for under the governing rules for the relevant superannuation fund, we'll talk about the case of Nugent later, the ending of a de facto relationship will not automatically revoke a binding death benefit nomination. Now, in Nugent, there was a specific provision within the terms of that, the governing rules for that super fund, that said if a de facto relationship had come to an end in those circumstances, it revoked that binding death benefit nomination. And the question in that case was, did the de facto relationship, or had it come to an end in order to revoke that binding death benefit nomination? The forma de facto, even where the relationship had ended, may still be entitled or considered as a dependent under the SIS legislation or the SIS regulations. So therefore, they may be entitled as a dependent or a financial dependent, or being in an interdependent relationship. And in the paper, I talk about a number of cases where it is relevant, or where the court has determined that, where AFCA has determined that, yes, the relationship came to an end, but because there was a dependency relationship between the parties, they remained entitled to all or part of the superannuation death benefit. Interestingly, under the terms of the Income Tax Assessment Act, the forma de facto will likely be treated as a death benefit dependent under the Income Tax Assessment Act, and therefore not pay any tax on receipt of that superannuation. Moving on to enduring appointments. In all states and territories, the ending of a de facto relationship does not revoke any enduring appointments, such as powers of attorney or enduring guardians. It's therefore vital that if you take instructions from a client where a de facto relationship has ended, that they do revoke any existing enduring appointments and replace them with persons who they would now want to make those decisions if they lost capacity. Looking at life insurance nominations, unless specifically provided for under the terms of the policy or nomination, the ending of a de facto relationship does not automatically revoke a life insurance nomination. It's also important to consider when speaking with your clients as to whether or not they should consider maintaining any life insurance policy after separation due to the financial needs if that party died. So if the de facto relationship had come to an end and in circumstances the other party died, there would no longer be child support. There would no longer be financial support in those circumstances. It may still be possible, and you might want to refer them off to get some advice about life insurance or taking out life insurance on their forma de facto. Entitlements on intestacy. So what is really clear is that the ending of a de facto relationship has the effect of disentitling the parties to any rights on intestacy. Now, the relevant legislation for each jurisdiction is listed in the paper. The core part, I suppose, where we have the ending of a de facto relationship and where we see lots of the legislation, and the core of my interest that peaked after a recent Tasmanian case is the eligibility to make a family provision claim. And there are differences between family provision laws in each state and territory. I really like some of them and I really dislike others. The one I really dislike is the one in my jurisdiction in Tasmania, which does not provide sufficient protection or provision for a forma de facto to make a claim against a deceased estate. In determining which laws apply, it's important to consider the following jurisdictional issues: the domicile of the parties, the location of the property, the time in which an application for family provision must be made, and whether or not the applicant meets the definition of eligible person. Again, they may be eligible in one jurisdiction, they may not be eligible in other jurisdictions. There are different timeframes that apply. Again, those are listed in detail in the paper, and I encourage you to read through this section in particular. Just going through in terms of what jurisdictions provide that a former de facto is eligible to make a family provision application. So in Tasmania, in Queensland, and in Western Australia. Now, I've grouped these three together on the basis that it talks about the fact that the person who was a former de facto partner must have been receiving or been entitled to receive maintenance from the deceased person, whether pursuant to a court order, to an agreement, or otherwise. Now, that language differs between the three jurisdictions, but what is really clear from case law, which I've summarised on this slide, is that an entitlement must actually be a crystallised right. It must be something that is enforceable by contract or by court order. It is not simply something that says you are at liberty to apply to it. It's you know, the cases make it very clear that it is quite distinct from merely having a liberty to apply for an order or a liberty to try and negotiate an agreement. And so that brings me to the situation in Tasmania, where if a party, if two people who were in a de facto relationship had ended that relationship, and before commencing family law proceedings, that party, one of those parties had died, it means that they aren't entitled to commence, which we'll come to in a moment, they're not entitled to commence family law proceedings. They also, in Tasmania and in Queensland and in Western Australia, are not entitled to apply for further provision. So they have to look at other ways in terms of trying to disentangle their financial interests. And the Tasmanian case, which I'll come to in a moment, provides a really horrible example of the outcome that results in, and that is that a party can be left without any rights to be able to disentangle their financial interests, which if the person had remained alive, they would have had the right to do, which if they'd been married, they would have had the right to do because they hadn't had the opportunity to disentangle their financial interests. In New South Wales, a former de facto is eligible if that person was at any particular time wholly or partly dependent on the person and was at a particular time or at any other time a member of the household in which the deceased person was a member. Now, there are interesting and complex factors that need to be proven in those circumstances. And again, I go into detail about that in the paper. This really is intended to be a summary in terms of addressing whether or not they're eligible to make an application and looking at the different legislation that applies in each jurisdiction. But again, I do go into detail in that in the paper, so I'd encourage you to read through this section in particular. In Victoria is absolutely my favourite legislation when it comes to legislation in relation to the rights of a former de facto to commence a family provision or make a family provision application. And that provides that if a former domestic partner who at the time of the deceased's death would have been able to take proceedings under the Family Law Act and has either not taken those proceedings or commenced but not finalised those proceedings and is now prevented from taking or finalising those proceedings because of the death of the deceased. Now, I've listed a case here of Stanovic and Roboskic. I'm sure I brutalised both of those names, so I apologise. But in those circumstances, or in that case, and I thought it was really important to provide an example here, given how much I have a preference for the Victorian legislation. In that case, the court went through and they looked at whether or not the person was eligible to make a claim, and they found that she was eligible to make a claim against the estate. And what was important, or one of the things that the court distinguished or made really clear in that case, was it wasn't the fact that they would have been, that the surviving former de facto would have been successful in a family law application. It was the fact that they had the right to commence those proceedings. The outcome of those proceedings did not matter in terms of determining their eligibility to make a claim. Now, in that case, the estate was worth $700,000, and the former de facto was successful in receiving provision of $550,000. It's a really interesting case, and I do encourage you to have a look at that one. We then have South Australian legislation. I have listed both the current legislation, but also the impending Succession Act and the changes to that legislation in South Australia, the ACT as well, and the Northern Territory. So it blows my mind that in 2024 we still have jurisdictions that have such distinct differences, and just over the border you can either be eligible or ineligible on the basis of the legislation that applies between those two jurisdictions. I'm advocating for changes in Tasmania on the basis that legislation just does not protect former de factos in circumstances where the relationship has ended and one party has died before they've been able to disentangle their financial interests. The factors that are considered once it's determined whether or not they are eligible to make a claim. I've listed each of these things here. It appears across each of the jurisdictions in terms of determining the factors when making a determination as to eligibility. Again, they continue here. And what's interesting is, once again, we see those factors that we saw previously, but also additional factors, which are quite similar to the considerations taken under the Family Law Act. Wrapping up in terms of the consequences of the ending of a de facto relationship, we have the eligibility to commence or continue family law proceedings. So what's really clear under the Family Law Act is that it is only possible to commence proceedings where both parties are still alive. In relation to the ability to continue proceedings after the death of a de facto partner, what's clear is that proceedings which are on foot may be continued by or against the personal representative of a deceased person, and that orders may be made or enforced on or behalf or against, as the case may be, the estate of a deceased party. So where orders have already been put in place, they can be enforced. The ability to continue proceedings after the death of both parties. If both parties die after proceedings have commenced but before final orders are made, then the proceedings will not continue. In relation to maintenance, what's clear under the Family Law Act is that de facto maintenance proceedings cannot be continued against a deceased person, and existing maintenance orders will stop when a party dies. Now, in those circumstances, we'd obviously then go and look at what family provision applications or the eligibility under family provision legislation in the jurisdiction may be relevant. Okay, that gets us through the chunk of it, and I'm glad that I still have time to look at the cases that I want to talk about. So the first case that I wanted to focus on is the case of Fairburn and Radecki. Now, in that case, Miss F and Mr R, who were both in their 50s, commenced a relationship in 2005, 2006. They lived together in a home owned by Mrs F, and they entered into agreements in 2010 and 2015, which were titled the cohabitation agreements. Essentially, what they provided for was that Miss F and Mr R would keep their assets separate, that they wouldn't combine their assets, and that regardless of what happened in their relationship, that they would keep their assets separate and not be entitled to each other's assets. By 2015, Mrs F began to suffer rapid cognitive decline. She was diagnosed with dementia. She qualified for full-time care in an aged care facility, and she was placed in there by mid-2017. Now, in April 2017, just as all of these things were happening, where Mrs F was moving into full-time care, Mr R took a planned 3-month holiday overseas. Now, was criticised for doing that. Mrs F complained about Mr R to her daughter, and she said that she had plans to separate from him upon his return. But she also said that she missed him. An enduring power of attorney, which was made in 2004 to Mrs F children, was activated in June 2017 whilst Mr R was overseas, and it was declared that the enduring power of attorney was in its enduring phase. Now, upon his return, Mr R sought to revoke the 2004 enduring power of attorney and to put in place a new enduring power of attorney which appointed Mr R and Mrs F's brother. A few months later, Mr R arranged for Mrs F to make a new will in favourable terms towards Miss Mr. R, including a life estate over the home to Mr. R. Now, this applied regardless of the fact that he had his own residence and regardless of the cohabitation agreements that had been entered into a long time prior to Mrs. F suffering any sort of cognitive decline. The relationship between Mr. R and Mrs. F's children was incredibly acrimonious. I think one of the judgment refers to at this stage the gloves were off. And unsurprisingly, NCAT appointed the New South Wales trustee and guardian as Mrs. F's guardian and financial manager. In March 2018, she was moved into full-time care on a permanent basis. Now, the New South Wales trustee and guardian wished to sell the home, Mrs. F's home, in order to fund her refundable accommodation deposit. Mr. R did not wish for the home to be sold as he lived there rent-free despite owning other properties himself. Instead, he proposed that a daily accommodation be paid and that the New South Wales trustee and guardian use Mrs. F's superannuation to pay for what that would fund up to 9 years of daily accommodation payments, after which he would pay the daily accommodation payment personally, provided that Mrs. F's estate refunded any payments to him after her death. So the New South Wales trustee and guardian sought to resolve the stalemate by bringing proceedings under Section 90 SM of the Family Law Act for property orders following the breakdown of a de facto relationship, including orders that the home be sold so that the refundable accommodation deposit could be paid. Mr. R continued to visit Mrs. F regularly, and at some stage he did make some daily accommodation payments without any agreement as to reimbursement. He also expressed a wish that Mrs. F would return home to live with him at some stage. Now, in the first instance, the Federal Circuit Court found in favour of the New South Wales trustee and guardian and found that the relationship had in fact come to an end. And through all of the circumstances which we'd previously gone through in this presentation, and found that the relationship had come to an end on the basis that there was a fundamental premise of the relationship, a fundamental premise of their relationship, Mrs. F and Mr. R's relationship, was that they would keep their assets separate. And it was unequivocally indicative and consistent only with the cessation of the de facto relationship as it had previously existed in terms of the circumstances that applied. Now, Mr. R appealed that decision to the full court, and the full court held that while some of the conduct of Mr. R was bad behaviour, it was not fundamentally inconsistent with the continuing of the de facto relationship. At most, the conduct demonstrated that a dispute existed between Mr. R and the trustee and Mrs. F's children about the best arrangements for her affairs. Unsurprisingly, the New South Wales trustee and guardian appealed that to the High Court, and the High Court found that the de facto relationship, in line with the judgment in the first instance, had ended no later than the 2nd of May 2018, finding that the circumstances demonstrated a persistent refusal by Mr. R to make the necessary and desirable adjustments. To use the language in Stanford, which is an interesting case which can be contrasted very strongly with the facts here in Fairbairn and Radecki. In Stanford, the wife had suffered a stroke, she developed consequential dementia and was placed into full-time residential care, whilst her husband remained in their residence. The husband continued to provide for her financially, contributing over $40,000 towards her medical needs. And the court in that case observed that when both parties are competent, it can be assumed that they will consensually make the necessary and desirable adjustments. So contrasting what happened in Stanford to what happened here in Fairbairn and Radecki, in Stanford, they did make the desirable and necessary adjustments. In this case, Mr. R did not make those necessary adjustments. When you consider the cohabitation agreements and when you consider Mr. R's persistent refusal to reside elsewhere and to permit the house to be sold, which was something that was clearly in Mrs. F's best interests, they found that the relationship had in fact come to an end. We then move on to the Tasmanian case that I have been referring to, and that's the case of GFR and SRP. I do want to provide a disclosure that this case concerns really quite disturbing factual circumstances and including sexual assault. And so just a warning for those of you who might want to prepare or step away. SRP and Mr. W were in a de facto relationship. They'd been in that relationship for about 7 years. That relationship had resulted in the birth of a child. They had purchased assets throughout that relationship, and as I understand, all of the assets had been purchased in Mr. W's name, despite both of them contributing to the purchase of that property. Now, a cabin and a house were built on that block. Again, as I said, they had a child together. In 2021, SRP had an affair leading to her temporary separation from Mr. W. Now, in circumstances where she later disclosed to him that it had been a sexual relationship that she had had, the facts in that case record that Mr. W violently assaulted her, and she left the property the following morning in order to stay with her parents. Now, SRP told a friend that the relationship had ended and that the separation was very definite and very permanent. Mr. W also told a friend that she's done too much. I will never be able to forgive her. There's no coming back from this. The relationship was over. Miss SRP also was said to have left her engagement ring on the kitchen bench when she left the house. And she was non-committal in discussions with Mr. W about whether they could repair their relationship. Mr. W died by suicide on a few days later, having not made a will. SRP sought a grant of representation on intestacy on the basis that she was his spouse, and she claimed that she was entitled to the whole of the estate. Mr. W's father, GFR, argued that the de facto relationship had ended, and accordingly, she was not entitled under the intestacy legislation that applied in Tasmania, nor was she a beneficiary. She wasn't entitled to apply for a grant, and she was also not entitled on intestacy. At the first instance, the court found that the relationship had not ended and that it had continued on an extremely fragile footing. They noted that financial disentanglement and the fact that she had not received any legal information from a lawyer, and although she had not taken steps to report the sexual assault, lots of different factors, but in first instance they found that the relationship had not come to an end and therefore she was entitled to the entirety of the estate. That case was then appealed to the full court of the Tasmanian Supreme Court, and the court on appeal found that the relationship had ceased no later than the time that she left the house and returned to her parents on the morning after the sexual assault. The factors that were taken into account, again, are listed here, but it just shows, and again, coming back to the frustration that I felt is in Tasmania, she would not be entitled to make a claim against the deceased estate. She would not be entitled to commence proceedings under the Family Law Act in order to try and disentangle their financial interests. So she was left with other potential recourses in terms of tortious recovery, equitable claims against the estate for the contributions that she'd made to the contribution to the property. And despite the judge listing that she would be entitled to apply for further provision under family provision legislation here in Tasmania, because there were no there was no maintenance proceedings on foot, she would not be entitled. Now, if we'd looked at Victoria and she'd been in Victoria, in this case it applied in Victoria, she would have had that right in order to apply for further provision. And it's just incredibly frustrating that she's left without, in this case, SRP was left without any ability to try and to try and disentangle those financial affairs where she clearly contributed to Mr. W's property. They had a child together, lots of different circumstances. The costs in this case, in terms of, I wasn't personally involved, but I can imagine would just have eaten up because of the acrimonious relationship between those two parties. Moving on to Nugent. So this is a superannuation case. And in that case, again, this is another circumstance of a relationship breaking down, suicide. Mr. C and Mr. N were in a de facto relationship. There was a non-lapsing binding death benefit nomination that Mr. C had made in favour of Mr. N. As I'd mentioned previously, the relevant governing rules for that superannuation fund provided that it would cease to be effective or it would be revoked in circumstances where a de facto relationship had terminated. Now, on the 1st of September 2019, 2019, Mr. C sent his sister the following text message, and you can read it there, but essentially saying that the relationship had come to an end, implying that after his death, he didn't want anything to go to Mr. N. And shortly after that text message was sent, Mr. C died by suicide. Mr. N made a claim for Mr. C's superannuation death benefits. The trustee decided initially that 100% was payable to Mr. C's estate on the basis that the de facto relationship had come to an end. Now, after an objection, they changed the decision to pay 80% to the estate and 20% to Mr. N on the basis that although the relationship had ended, as I mentioned before, that the two had remained in an independent relationship as they'd continued to provide financial support, or they were providing financial support to one another. Mr. N complained to AFCA, and he was successful in those circumstances where AFCA found that the de facto relationship had in fact not ended, and the death benefit was allocated to Mr. N in its entirety. There's a relevant paragraph taken from the AFCA decision there, where it talked about relationships having their ups and downs, and the fact that the communication of one party to a third party that a relationship had come to an end was not sufficient in order to end that relationship. There was an appeal to the federal court, and in that circumstance, Mrs. C, who was the deceased's mother, was successful, and the court, or the federal court, held that the de facto relationship had ended and that the binding death benefit nomination had been revoked. And in that case, Justice O'Callaghan provided that AFCA erred as a matter of law in finding that the text message was not effective to terminate the de facto relationship between the two parties within the meaning of the relevant governing rule, because the only construction of that text reasonably provides that Mr. N had intended to terminate the relationship. Also providing there can be no doubt of unilateral intention of one party where it's not communicated to the other that it can bring an end to that relationship. So what that shows us is that the ending, so one party to a de facto relationship can effectively terminate the relationship without communicating to the other party their intent to do so, nor does termination require some overt act of separation. Unsurprisingly, that was then appealed to the full court of the federal court, and Mr. N was successful. Now, in that case, the full court of the federal court found that Mr. N was entitled to receive, I apologise, that should say, that should not say Mrs. C's death benefit, but they were valued at over $1 million. And really, unfortunately, Mrs. C was ordered to pay the cost of Mr. N's costs in the appeal. The court went through and found the reasons why the relationship had in fact not ended. It says one party to a de facto relationship can effectively terminate that relationship without communicating to the other party their intent to do so, and that termination does not require some overt act of separation. However, on the facts before AFCA, it was open for AFCA to find that the spousal relationship had existed based on the living arrangements of the two parties, and that the text message itself was ineffective to terminate the relationship. So what this case and what each of the cases that I've tried to summarise in the presentation shows is that these are so fact specific that one court may make one decision, an appeal may provide the exact opposite of that decision, and then a further appeal may provide back to what we were. So it just flip-flops in terms of when you're reading a decision, there's no certainty in terms of whether or not a de facto relationship is going to be determined as of ending. When we find the next case, which I'm not going to have the time to go through today, but when we look at that case and we compare that to GFR and SRP, the facts are very similar. The facts are, in this circumstance, the relationship broke down. This was a superannuation determination in terms of, whether or not the de facto relationship had come to an end, whether or not the party was entitled to superannuation after the death of that person, and whether or not that de facto relationship had come to an end. It's so clear that it really is fact dependent, and that where you might have one decision which went one way, you might have a completely same set of facts in another context, in another jurisdiction, which might go completely a different way. Other cases which I do summarise within the paper are the case of Sheen and Hassan, the case of the estate of HRA and deceased, and the estate of Daniel Claudio Legler. Now, each of those cases are interesting in a different way. If I was just to, in the remaining time that we have, to go through the facts in that case, a simple summary of the facts in that case. So in Sheen and Hassan, it was a secret de facto relationship, but it had ended prior to Mr. Z's death. However, they found that the former de facto was eligible to bring a claim under Section 57E of the New South Wales Succession Act as a member of Mr. Z's household who was partly dependent upon him. Now, in that case, really interesting, the secrecy of that de facto relationship was brought about by for religious reasons, in circumstances where one was a devout Muslim, the other one had grown up in a Catholic cult. His family didn't know about the relationship, her family didn't know about the relationship, but it was really clear that the de facto relationship had existed, but it had come to an end prior to his death. Now, in that circumstance, she made an application for further provision and she was awarded 15% of the estate in that case. What's really interesting, look at paragraph 408 of that decision, where the court defines or provides the Oxford definition of friends with benefits. And that was an argument in that case where the siblings of the deceased had argued that they weren't in a de facto relationship, that they were no more than friends with benefits, which is an interesting thing, I suppose, in the context of relationships and what we have to consider now when looking at de facto relationships, whether a relationship existed, what the extent of that relationship was, and whether or not what may amount to the ending of that de facto relationship. In the case of the estate versus HRA and the deceased, it was found in that case that a de facto relationship did not exist for at least 2 years prior to the death. And that was in circumstances where one of the parties had capacity to maintain contact. So again, a de facto relationship, they were living together. One of them needed to move into elder care, and upon that person moving into elder care, the remaining party just ceased any contact, didn't write, didn't care, didn't involve herself in any way in his care. Now, there are also questions of her capacity to do so and whether or not she physically had capacity and at a later time mentally had the mental capacity to be able to continue to engage in that relationship. But in circumstances where that case, even though there was what was an informal will document, or could have been an informal will document, the court found that that relationship had come to an end and looked at Fairbairn and Radecki and the factors in terms of that mutual commitment to a shared life, and found that the relationship had come to an end. In the estate of Daniel Claudio Legler, again, this is a really interesting case and I would encourage you to have a look at that case. But it was a non-conventional relationship that was found to have satisfied the criteria for a de facto relationship in New South Wales. The deceased died leaving his estate sort of almost entirely in Portugal, and leaving other assets in New South Wales, in Liechtenstein and in Malta. One of the interesting things that I encourage you to look at, particularly where you have clients who have assets overseas in other jurisdictions, is the consideration of domicile. Now, the majority of the deceased's property was held in Portugal, and the determination of the New South Wales Supreme Court as to whether or not the de facto relationship had existed was one factor, but the other factor was where he was domiciled. And the New South Wales Supreme Court found he was domiciled in Portugal, and for that reason, that meant that Portugal's laws applied, which did not recognise a de facto partner. So she was found to be a de facto, but under Portugal's laws, he was where he was found to be domiciled. In those circumstances, she would not receive any entitlement because Portugal's law would have applied in comparison to the New South Wales legislation, which would have applied, and therefore the likelihood is that she would not be successful in Portugal. Now, it's understood in that case that it is subject to an appeal decision in terms of the domicile type question. Moving on, I suppose, to questions. I've had a look here and I can't necessarily see any questions. So I will wrap up in the remaining little while that we have here, and that is to make a number of comments. It is vital where clients come to you and they are in a de facto relationship or they have ended a de facto relationship that we consider the impact of entering into that de facto relationship or that de facto relationship ending is going to have on the entirety of their estate plan. It's not just enough to think about their will. We have to be thinking about each of those factors that I've mentioned here today. It is vital that a new estate plan be put in place, that a review of each of those documents be put in place. It's really important if the client or the person who comes to you has assets in different jurisdictions or has different types of property under a trust, under superannuation, under life insurance, within the estate generally in terms of whether there's a will or whether it's an intestate estate, that we look at the different legislation because the outcome may be very different because we have such differing laws and different provisions that apply depending on those assets. I really hope that you've enjoyed today. This is a minefield of considerations when it comes to the way we practice in estates, and I think it really provides a great example of how estate planning, estate administration, and estate litigators need to be aware of so many different areas of legislation: property law, family law, trust law, estate law. It applies so broadly, and we must have a knowledge of each of those things in order to advise our clients properly. Thank you all very much for joining me, and I hope that you enjoy the rest of your day.
Thank you so much, Kimberly, for an excellent session today. And thank you, everyone, for participating in today's event. You will be redirected to our online exit survey shortly. We ask you to please take a moment to complete the survey as your feedback is very important to us. We thank you in advance for your feedback, wish you a pleasant afternoon, and hope to see you at another event by 10, the Education Network soon. Thanks again, everyone.